Okay.
Hello, UK Property World, and anyone else who's viewing this. We'd like to, I suppose, introduce Julie Ford, who is one of the UK's leading letting advisory experts. Julie will give us a little bit of a background. She provides a lettings advice service, which is, ever more popular given I suppose, the incoming changes to legislation and the general need to be compliant as both a landlord and a letting agency. So, Julie, thank you so much for coming on. We're really looking forward to your presentation today about the Renters' Rights Act. And but before we get started, would you mind giving a brief intro for those of you not familiar with your background and area of practice?
Yeah, absolutely. So my name's Julie Ford, as it says on the tin. I've got 32 years working in this glorious industry. I started as a property manager because I soon worked out that I couldn't sell anything to anybody, and I was a fixer by nature. So property management was where I fell into. I was lucky enough to manage properties for celebrity landlords, most of which I can't talk about. However, Ricky Gervais doesn't mind me mentioning his name whenever I can. I then spent 6 years going over to the dark side, and I worked as a housing and homeless law specialist for the Citizens Advice. I'm also an industry trainer delivering training for both Shelter and the NRLA, and I'm also on the Zoopla advisory board. Now, most of you will know me as a property commentator. I feature in as many places as I can in the media as possible. I've been behind the scenes working on shows such as The Week the Landlord Moved In, and I'm also quoted regularly in the industry press. Predominantly GB News, it's where you'll find me these days. They seem to want me on there quite a lot, so I spend my weekends normally in the studio down there. I'm also a qualified mediator, having completed over 500 mediations between landlords and tenants, including letting agents in there as well. And that was when I was contracted to the Property Redress Scheme. So that's me in a nutshell. And then we will be talking, obviously, about the Renters' Rights Act.
Super. Well, yeah. So no better person to us present on this topic. It's forefront of many landlords and letting agents' minds. Just understanding what's changing and what are the key changes.
Absolutely. So I'll move on to those straight away. So obviously, as we've all heard in the press, the most important thing is Section 21 is being abolished. It's not actually as scary as it sounds. I think over the years, we've just got used to using Section 21 as our lazy, easy option because there's nothing for the tenant to basically counterclaim against or anything like that. So we've just got a little bit complacent with Section 21, and obviously the end of fixed term tenancies. So that means at the moment, it's really common to enter a tenant into a 6, 12, or maybe even 24-month fixed term contract. But come the 1st of May, when this new legislation comes in, there will be no more fixed term tenancies. Everything will be month by month rolling. Now, that includes if you're entering into a fixed term tenancy now, bear in mind that on the 1st of May, your fixed term will automatically end and it will become the new periodic tenancy, regardless of how many months you have left on the end of that fixed term. Then we have rent in advance, rent increases, and rent increase appeals. I've bunched this together because they kind of all flow into each other. So rent in advance, what do I mean by that? So at the moment, if a tenant doesn't pass referencing, or maybe they have a non-common way of earning their income, maybe it's up and down, this, that, and the other, then ultimately we would take rent in advance. We would take maybe 3 or 6 months rent in advance to give us that extra security. We can't do that once the new Renters' Rights Act comes in, and you will only be able to take the first month's rent, but you cannot take that until the tenancy agreement has been signed. So, what does that mean in practicality? Basically, once the tenant has signed on the dotted line, you can demand the first month's rent. If they don't pay it, you still have to give occupation because they've entered into that contract. It's very unlikely that that's going to happen. Most tenants don't normally go through the stress of referencing, paying deposits and everything like that purely to shaft the landlord on day one. But it's something to be mindful of. It also might increase the commonality of the Airbnb party houses. So if you have a property where they don't have to pay the first month's rent, they're only paying the deposit. If we're then looking at how the rent arrears are going to change, people could be in a property for around 3 to 4 months without paying any rent before any legal action can be started. This could mean that it's a great business opportunity for somebody to jump into a property, not pay any rent, but just pay that security deposit and make a fortune in that 3 or 4 months. Best way to avoid that is rent your properties without furniture in. Nobody's going to want to rent an empty property, then have to furnish it just to be able to skim some money off the top. Rent increases. So at the moment, the way we can increase rent with our tenants, there's several ways. First of all, you'll have a rent increase clause in your tenancy agreement. Normally that will say that it's against the retail price index or a specific percentage that you're increasing your rent by. Or you can have a mutual conversation with the tenant and agree what the new rent is going to be. Or if you have a statutory periodic tenancy, you're issuing a Section 13 notice. Under the new regulations, the only way to increase rent formally will be the Section 13 notice. Currently, that notice is 1 month's notice. That's going to increase to 2 months' notice. So you need to bear that in mind when you're looking at when and how you're going to be increasing your rent. Just like now, you can only increase rent once a year with the same tenant, so no real change there. But of course, if you have a change of tenant, there's nothing stopping you looking at what the market is doing and increasing the rent accordingly. Rent will also only be able to be increased against market rate, no other denomination. So whereas, like I said before, we might have looked at the consumer price index or the retail price index, we're not looking at those anymore. We're purely looking at the market rent. So that's what's going on your immediate doorstep. So it's going to be important to know what's going on in your community. Rent increase appeals. Just like now, the tenant will be able to appeal any rent increase that you put forward. Now, there's 2 points that a tenant can challenge the rent. The first, interestingly enough, is within the first 6 months of move-in. Now, again, that hasn't changed. That's exactly how it is now. So yes, your tenant has seen your advert for £1,000 a month. They've signed on the dotted line, £1,000 a month. Within the first 6 months, if they don't agree with that £1,000 a month, they do have the opportunity to take it to tribunal. Now, how successful they'll be is another conversation altogether. The next opportunity they have to challenge the rent is, of course, when you're issuing that Section 13 notice. They will have the opportunity to take it to the first tier property tribunal. Now, the issue with that is the new rent will only take effect once the tribunal has made a decision. Obviously, that's only if the tenant is appealing. If the tenant hasn't appealed, then your rent will take effect within the 2 months that the Section 13 notice is. So if you have got a rent increase and it's taken to tribunal, I looked at the facts for 2024 because I love a fact. And in 2024, there were 900 rent increase cases taken to the first tier tribunal. Now, bearing in mind, we have around 11 million renters in the sector, 900 was pretty much a very small drop in the ocean. However, those 900 actually took around 8 months on average to get a decision. So if you think every tenant might now be aware of this regime and they all start peeling their rent increases. I haven't seen any job adverts go up for any new tribunal staff. So it could be that we double, triple, or even quadruple the amount of increases being challenged. This also means that the amount of time it's going to take is going to increase as well. So when you're looking at rent increases, when you're looking at your ROI, it's really important to understand that if you're increasing your rent every year, if the tenant kicks the can down the road because there's no cost to the tenant to challenge their rent increase, you may actually only be getting a rent increase maybe every 18 or 24 months. So tenants, 2 months notice. So at the moment, tenants are quite restricted when it comes to when they can leave. First of all, when they're tied into a fixed term contract, they can't genuinely leave unless the landlord agrees, and we call that early termination. And under the Tenant Fees Act, the tenant can be charged for the cost of reletting if they want to leave early. If they want to leave on the very last day of their fixed term tenancy, they don't have to give any notice at all. It's helpful if they do, absolutely, but they don't legally have to. And then once it moves into periodic, then they only have to give 1 month's notice in line with their rent due date. Under the Renters' Rights Act, because we will only have periodic tenancies, tenants will be able to give 2 months' notice. So it's been increased from 1 to 2, 2 months' notice at any point. This is the bit that is going to be the stinging the tail. Any point, including on the day of move-in, as long as their notice ends on either the first or last day of a rent period. So it could possibly be that you hand over the keys as the tenant is giving you an envelope to say they're going to leave. I do think this is going to be an extremely rare situation, simply because, again, like I said, tenants aren't going to go through the stress and the rigmarole of being referenced, paying rent, paying a deposit, moving, everything like that, just to be in somewhere for 2 months. But the law does allow them to do it. It also means when it comes to joint tenancies, because we are now working with periodic tenancies and not fixed term, one tenant can give notice for all tenants. We commonly call it one out, all out. So what this means is if you have, I don't know, 5 tenants on a joint tenancy agreement, and John decides he doesn't want to be there anymore because someone keeps eating his cheese, he can give notice, and that notice will end the tenancy for everybody. The other joint tenants don't have to know the notice has been served, and the other joint tenants don't have to be in agreement with the notice. So of course, this is going to cause some issues when you are looking at properties maybe who have students who maybe aren't getting along, or any other situation where you've got shared accommodation where people may not be as friendly with each other as maybe they could be. Renting with pets. And I know this is one that's in the media quite a lot. And the media would like you to believe that landlords now have to accept pets regardless, no matter what. It's not true. It really isn't. You can still advertise a property and say no pets. That will be perfectly legal. There's nothing wrong with that whatsoever. But if a tenant wants a pet, they will have to ask you in writing. That in writing is quite specific in the legislation of what it must include. So, first of all, it must include the type, breed, sex of the animal, and then any other information that will help the landlord make an informed decision. So, if you want more information from the tenant, you can ask for that. And that then gives you a little bit more time. So at the moment, when the tenant asks in writing to have a pet, a landlord will have 28 days in which to give a decision, whether that's yay or whether that's nay. If the landlord wants more information, they can ask for more information, and that 28 days gets extended by a further 7. Landlords can refuse, but the refusal must be reasonable. So, for example, it's going to be on a case by case basis. If you have a superior lease that says no pets, pretty much not a lot you can do about that. That's going to be a reasonable reason to refuse. If you have a property that is a studio flat and said tenant wants to bring in a Great Dane, there is reference to tenant and pet welfare when it comes to the Act. So obviously a Great Dane probably isn't going to fit in a studio flat. So that's a reasonable reason to refuse. HMOs, absolutely, blanket ban. We totally understand that. HMOs are much more fluid when it comes to tenants moving in and out. Allergies are probably going to be much more common to interact with. So no pets in an HMO, 100% perfectly reasonable excuse. But again, like I say, it's going to be on a sort of case by case basis. Other things that might be reasonable is if the landlord is going to move in immediately after this let and the landlord has severe allergies, could refuse a pet on those grounds. I've also had queries about religious grounds. So, for example, Muslims do not allow dogs inside, although dogs can be outside a property. If a landlord is Muslim and is looking to move into the property immediately after this let, there could be a legitimate reason to refuse dogs inside the house. But again, it's all going to be on a case by case, and the legislation doesn't give a list. It is going to be about us using common sense. We're going to bring that back, which is quite nice. Then I'm going to move on to possession grounds. So with the abolition of Section 21, the only way that we can evict our tenants now is by using Section 8. Now, we already have Section 8, but we're going to have some new grounds. We currently have 21 grounds under Section 8. We're going to have another 15 added, so we'll have 36 grounds to choose from in regards to evicting our tenant. Now, I think the most common ways or reasons that landlords will want to evict is because they want to sell or they want to move back in. Obviously, we're still going to have the rent arrears, antisocial behaviour, and I'll talk about those in a second. So we have a new ground being introduced, which is ground 1A, and that is if the landlord wants to sell. So there are some caveats and restrictions on it, of course. So the ground will be 4 months' notice, and it can't be issued to expire within the first 12 months of the tenancy. So what that means in English is if your tenancy started back in 2018 and you haven't renewed it since, it's just gone periodic, your 12-month clock started back in 2018, so you can serve this 4 months notice at any point. If you've just signed on the dotted line today, for example, you'll have to wait 8 months before you can serve your 4 months notice so that it expires after the end of 12 months of occupation. So that's important to get your head around. Now, if you're using this ground and ground 1, which is one we currently have, which is the landlord or if landlord's family member want to move back in, the same restrictions apply to both grounds. So the 12-month rule, it can't expire within the first 12 months, applies to both. But also you cannot re-let your property within 12 months of using this notice. Now, there's 2 points that this 12-month kicks in. First is the date the notice is issued. So let's say you're issuing it at month 8, then that's when your clock starts for not being able to re-let. Now, 4 of those months are going to be absorbed by the notice itself. So you've only got a few months left. If the tenant does not vacate after the 4 months notice and you have to go through the court process, then your 12-month clock starts when you put the court papers in. So you have to be mindful of which one of those 12-month clocks is going to start for you. Now, when we talk about re-let, we literally mean re-let in any way, shape or form. So whether that's back on an assured tenancy, whether that's Airbnb, whether that's holiday let, whether that's serviced accommodation, that's what it means by re-let. So you have to be really careful. Now, if you don't use one of those 2 grounds, so if you're not using ground 1 and you're not using ground 1A, those restrictions don't apply to any other ground under Section 8, just those 2. Then we still have our usual ones. So rent arrears, which is grounds 8, 10 and 11. So ground 8, the tenant must be 3 clear months in arrears. Currently it's 2, that's increasing to 3. And the notice period is 4 weeks. That's doubling from the current 2 weeks notice. So realistically, that means a tenant will technically be 4 months in arrears before a landlord can apply to court. So it's worth, when we're looking at rent arrears, to ensure that as landlords, we're nipping it in the bud as soon as we can. The second that tenant is a day late and a penny short, pick up the phone and start having those conversations. Then we've still got our antisocial behaviour ground, which is ground 7A and ground 14. So at the moment, ground 7A is 4 weeks notice, but that's going to be removed and the notice is going to be immediate. That's to fall in line with ground 14. So ground 7A, the tenant must have been convicted of an antisocial behaviour offence to be able to use this ground, whereas ground 14 has some peculiar wording. It is the tenant is likely to cause a nuisance. Well, any of us are likely to cause a nuisance. I certainly am after a couple of glasses of wine. So, you know, how do we interpret that and how do we get the evidence for that? So that's something that once the legislation is released, we're going to have to look at in more detail. Certainly getting evidence, written witness statements, reporting incidents to the police, crime reference numbers, all of those things will help. So what do I mean by immediate notice? What I mean is that if you are serving the Section 8, ground 7A or ground 14, you can serve it at 9 o'clock on a Monday morning and you can apply to court at 1 minute past. There is no notice period for the tenant. So increased fines. So at the moment, you can get fined for not doing the correct things. So For example, not having an energy performance certificate, not having a gas certificate, not having your electrical certificate. But those fines are going to be increasing. So currently they start at 5,000, they go up to 30,000. Those fines are going to start at 7,000 and they're going to go up to 40,000. And then councils will have additional powers to either pursue civil or criminal prosecutions. So getting it right is going to be super important. Now, you can be fined for pretty much anything under the Renters' Rights Act, unfortunately, including looking at your tenant funny if you read the wording correctly. So you can be fined if you are not a member of the database, if you're not a member of the new Ombudsman, and I'm going to talk about those in a bit more detail as well. If you have issued the wrong tenancy agreement. So, for example, you just automatically issued a fixed term, but forgot you are now on periodics, you can get a fine for that. If you are issuing Section 8 and you're using the wrong ground, you can get fined for that. You must get fined for anything. So it's really important to know what it is you need to be doing and make sure you don't fall into any of these traps. Landlord database and the new Ombudsman. So the database is pretty much exactly what it says on the tin. It will be a database of landlords in England that anyone can have a look at. And I do mean that genuinely. At the moment, it is going to be a public database. On that database will be your name, your address, your contact information, and anything relating to the property. So any license that may be required, all of your compliance documentation, like your gas certificates, your EICRs, they all go on there as well. And also any fines or penalties that the landlord has had. Now, I do mean anything relating to property. So if landlord has been done for drink driving, that won't be on there. It is going to be purely property related. And then the new Ombudsman, this is exactly the same as the redress schemes that letting agents currently have to be a member of. So this is going to be a standalone scheme. It won't be one of the existing property redress scheme or the property ombudsman. It will be its own standalone private sector ombudsman. Every landlord will legally have to be a member of this ombudsman, the same as they are with the database, even if they are using an agent which is a member of their own ombudsman. So basically, we're double dipping here. If you are not on the database and you're not on the ombudsman, or your details on either are not up to date, you will be part of those fines that I talked about earlier. You'll also be unable to evict. And this is going to be something that you're going to have to be really aware of. If your details aren't correct on either of these, the ombudsman or the database, or you're not a member, you won't be able to evict unless you're solely relying on the two antisocial behaviour grounds. They are only caveat. And then we have Decent Homes and Awaab's Law. Now, I'm not going to expand on those too much, simply because, as you'll see from the next slides, they are so far into the future, I wouldn't even be worrying myself about them now. Basically, Decent Homes Standard has been in the social sector since 2000. Their Decent Homes Standard was updated in 2006, and it basically sets exactly what it says on the tin, the basic standard of property when it's rented out and how it is to be maintained to what level. Now, there's quite a lot in the social Decent Homes Standard that I do not expect to come across the private sector. Things such as bathrooms must be replaced every 30 years and kitchens every 20 years. Now, obviously, councils and social housing providers get a budget from the government to do that. So unless Rachel Reeves is going to find another black hole that she needs to fill, I'm quite sure landlords are not going to be getting a little helping hand from the government to replace kitchens and bathrooms. Also, a lot of properties in the private sector, and I think last time I did some searching, it was just over 52% of the properties in the private sector were actually pre-World War II. So you've got to think how old those properties are. And a lot of those bathrooms and kitchens have actually the bespoke features that people want. They love all of that. So having to rip them out and put in a new Wren kitchen in is not going to be very nice for the property. So I can't see things like that coming forward. Awaab's Law, those for you that do not know, Awaab Ishak was a 2-year-old little boy who lived in a social housing property provided by Rochdale Council. His mum and dad reported issues with damp and mould in the property time after time after time, and they weren't listened to. The damp and mould was a property issue. It was not their lifestyle. And unfortunately, Awab Ishak passed away from complications to his respiratory system because of the damp and mold. Therefore, Awab's law was introduced. It's just been introduced into the social sector. That was, I think, October, if I remember correctly. And that gives strict timelines of how landlords are to react and be proactive when it comes to damp and mold reporting. Obviously, it hits harder with social landlords. And if any of you take the time to read the Housing Ombudsman bulletin that comes out, you'll see the amount of local councils and housing associations that have maladministration when it comes to damp and mold. So again, if you are maintaining your asset, so making sure that it increases in value and doesn't decrease, Decent Homes and Awab's law should not be too much of an issue for you. So let's look at the roadmap. Where is all of this going to happen and what do we need to do at what point? So 27th of December this year, so literally, where are we, 15 days away, new regulatory powers come into force for local councils. So what this basically means is the councils now will have to investigate anything that they feel a landlord or letting agent isn't doing correctly. Now, what they can't do is enforce anything that's under the Renters' Rights Act, because that doesn't exist yet. But if you have things like you're a letting agent, for example, and you don't have your client money protection on your website, or you don't have your property redress scheme on your website, they'll be clamping down on that. Those are the sort of things they'll start investigating. Once the new legislation comes in, the councils will be able to walk into any premises, whether that's residential or business, and take anything they need to basically prove that you're not doing what you should be doing correctly, whether you're a letting agent or a landlord. So if you run your business from home, the councils can walk in without a warrant and take any documents, computers, anything they need to validate their suspicion that you're not acting correctly. So get your ducks in a row now. That's going to be super important. Now, how the councils are going to manage that, they're already understaffed, they're already going bankrupt, I don't know. But anyway, these are the new powers that they have. So from January 2026, the new written statement of terms will be published. So this is the document that you will need to give any tenants that you currently have where you don't have a written agreement in place. This is one where you've had a verbal agreement or a gentleman's handshake, or it's all done over a pint down the pub. You can't have those anymore. You will have to have written contracts. Now, it doesn't mean you have to have a big old tenancy agreement. This written statement of terms is the bare minimum you will need to have to legally put a tenancy in place. So you'll need to make sure that all of these are ready to be issued between the 1st of May and the 31st of May. You can't issue them early, sadly, even though they're producing them early, you can't get ahead of the game. And we've also got new commencements for financial penalties for category 1 hazards in the private rented sector. So category 1 hazards, they come under the Housing Health and Safety Rating System. And if anybody can't sleep, I strongly recommend you download and have a little read of that. You'll be asleep in seconds. And that has 29 categories where you can be fined or something like that. Category 1 hazards and category 2 hazards are very different. Category 1 is an immediate threat to life in some way. So extreme cold, extreme heat, those sort of things. Whereas category 2 are, can you get it fixed in the next sort of 7 to 14 days, please? So much less of a struggle. So that's January. March, that's our next point in our diary. That's publication of the information sheet. So this is the document that you'll legally have to give existing tenants to explain to them the difference between their current AST and the new periodic tenancy that is going to come into effect. Again, you'll need to do this between the 1st of May and the 31st of May to ensure that you are legal. If you don't do any of these things that I'm talking about in the roadmap, you are going back to those fines again. They start at 7,000, they go up to 40,000. They could be criminal or civil prosecutions. 4 p.m. on Thursday, the 30th of April, 2026. That is the very last moment you can serve a Section 21. That's it. From that point onwards, no, you're done. It no longer exists. So if you need to be serving them, that's your final date. And then Friday, the 1st of May, that is when the Renters' Rights Act becomes law and all of these changes take effect. So like I said, on or before the 31st of May, so that's between the 1st of May and the 31st of May, you need to have issued your information sheet to existing tenants to tell them the difference between their current AST and their new tenancy. Any verbal tenancies have now been converted to written tenancy agreements with that written information sheet with the bare basics on. And landlords who have got current HMOs that want to rely on the new student eviction ground will need to make sure they have issued the tenants with prior notice. Now, if anybody wants me to talk about the student ground, I'd be more than happy to do that. It is a little complex and usually it does create quite a debate. So it's entirely up to you. If none of you are student landlords, then I'm more than happy to not discuss that. Then the next date is the close of business, Friday, the 31st of July. And that is any Section 21 or Section 8 that has been served before the 1st of May 2026 will automatically lapse. It will no longer exist. Poof, it's gone unless you've got your claim into court, unless you've put your court papers in. So that's your very last day to get court papers in. So just be mindful of that. And then the very last dates, and this is why you can see I didn't focus too much on Decent Homes and AWAB's law. So late 2026, that's when the database is going to come in. That will be an initial rollout. So they're going to start up north and then roll it down the country. Don't know how long that's going to take. We don't know yet. 2028, that is when the Landlord Ombudsman is going to be launched, and everybody will need to have joined by the end of 2028. And as you can see there, yes, I do have the date right. It is 10 years in the future, Decent Home Standard and AWAB's law. So where did I get that date from? So a couple of months ago, the government released a report after a long consultation on bringing Decent Homes and AWAB's law into the private sector. In that report, they specifically used that date of 2035. So we know that's the date they're aiming for. So at the moment, that's the date that I am working with. So I am done. I think I managed to whirlwind that. Any questions? And like Will said, I do run the lettings advice service. If you want ongoing advice, please do scan the QR code. And obviously myself and my team will be more than happy to support you. If anyone's got any questions, or if you want me to go over the student ground, I'd be more than happy to do that.
Well, firstly, Julie, that was absolutely fantastic to summarise a very complex piece of legislation in plain, simple English and in quite a well-structured way that both flowed into a timeline and gave some quite practical summaries of where it all fits together. So well done on that clarity, and thanks again for coming on. I think what we'll do is if anyone has any specific questions, I'd encourage you to reach out to Lettings Advice Service, which is Julie's business. And as a second here, to either write or do a short video asking the specific question in the event thread or in the comments below the post that you're seeing this. So Julie, that was absolutely fantastic. Really appreciate your time. Ultra expert on something that's very much in people's minds. So well done.
Thank you.